Ladies and gentlemen, you have heard all of the testimony in this case. You have received all of the evidence. Throughout the testimony in this case, you have heard that investigators followed that evidence. That evidence figuratively and literally led us to Chad Trollen Isaak. His vehicle matches the suspect vehicle in all unique features. We can see this from the comparison photographs with our own eyes. Down to the green bucket in that passenger seat, the mud on the front bumper, the rust on the black tire well, the black rails, the single black handle, the third door, the rims. All of these and more made it possible for Detective Cromer to see that vehicle, to recognize that vehicle, and to call other law enforcement officers to confirm that Chad Isaak's vehicle was the suspect vehicle we were looking for.
During the opening, we told you what we believed the evidence would show in this case. We did not then, and we do not now, dispute that a vicious series of crimes occurred on April 1st. That is clear, and it's undisputed. But as I said on the opening, this case is not about what happened, but who. And to determine that, you need to know why. This case was solved in law enforcement's view in 4 days. Supervisory Agent Arnie Rummel made that clear. We don't need labs. We don't need motive. We just need a few clothing items, some gun parts, a knife, a pickup with rust on it, and his opinion. This is a classic case of confirmation bias. There was really no real investigation after April 4th that focused on anybody except Dr. Isaak. This arrest was premature, and everything done after that was to confirm the judgments that they prematurely made.
I'm a former prosecutor, so I got to jump in here just for a second. Most cases, and I think true crime folks know this, most cases are solved in that first 48 hours anyway. That's when you solve the case. It's when it lingers past that the doubt starts to rise. But criminal defense attorneys will do it one way or the other. I mean, if it takes 6 months or 2 years to solve it, they'll use that against prosecutors. But if they solve it quickly and it leads to them, they use that. So just take it with a big grain of salt. But both sides making their arguments nonetheless. Chanley Painter, Court TV legal correspondent, is in Mandan, North Dakota, and has more on the verdict watch tonight.
The jury in the Chad Isaak trial did not reach a verdict today after working about 3 hours deliberating the fate of Chad Isaak. It's a jury of 6 men, 6 women, and they spent the day today listening to the attorneys present closing arguments. The prosecution methodically laid out its case step by step to the jury earlier today, using a visual PowerPoint to remind the jurors of the evidence in the case, from the surveillance video to the forensics, recapping the expert testimony about the blood evidence in Isaak's trunk and those bright orange fibers.
Robert Faulkner's blood is on Chad Isaak's vehicle, and there's no excuse, there's no rational explanation for that except that Chad Isaak committed these murders and transferred that blood when he got into his vehicle at McDonald's. Lois Cobb can also not be excluded from that sample. On the swabs of the third door latch, there's again blood that matches Chad Isaak and also cannot exclude Robert Faulkner as well as Lois Cobb. Think about the crime scene. Doesn't it make sense that the 2 most brutal murders, Lois Cobb and Robert Faulkner, would result in blood transfer to their assailant? I argue to you, ladies and gentlemen, that is exactly what happened in this case.
The defense countered for an hour and a half, arguing to the jurors that the investigators rushed to judgment in this case and that the crime scene was contaminated by the first responders, and there's no motive for Chad Isaak to commit this brutal crime. Specifically, the defense countered the state's theory that this crime could have been committed by only one person.
Concerning the time that likely occurred to kill Robert, Dr. Masella initially stated 1 or 2 minutes, then later he clarified and said within 5 minutes. The suspect leaves at 7:08, but when the seconds are added back in, it's clear that from the time of Robert's entry and the suspect departure, 1 minute and 20 seconds had elapsed. The witnesses agree that the suspect did not return. The government tried to get Dr. Masella to agree that all these crimes could have happened within 21 minutes. That's the time he first comes in the building and is later seen leaving for the last time at 7:08. Dr. Masello's testimony as a typical doctor was, quote, theoretically, end quote. But that time frame is the entire time frame that the orange-clad suspect entered and ultimately left for the last time. That does not include the time spent walking to the office area where the Cobbs were murdered or walking on camera inside and outside the RGR building. When those times are excluded, it's 12 minutes total or less, not 21 minutes. And 1 minute and 20 seconds to murder Robert. It's impossible with this timeline and the testimony from Dr. Masella and others for one suspect to have committed these crimes.
Inside the courtroom this morning during closing arguments, a sea of maroon shirts from the RJR Maintenance and Management, the employees, family, and friends of the victims. A show of support, something the jurors definitely noticed this morning inside the courtroom, and those family members stuck around all day long waiting and hoping for a verdict today. But this jury will return to the courthouse tomorrow to resume deliberations. Chad Isaak does face 4 counts of murder and, if convicted, could spend the rest of his life behind bars. I'll send it back to you.
Hanley Painter in North Dakota tomorrow morning. Make sure you tune in first thing. Verdict can happen literally at any moment once they start deliberating. We have no idea. Maybe they came really close today, or they're going to come close, first thing in the morning. You just don't know. Okay, let's bring in our think tank tonight. Joining us in the Bronx, New York, criminal defense attorney Renee Hill. In Houston, Texas, criminal defense attorney Carmen Rowe. And in Atlanta, Georgia, criminal defense attorney, law professor at Emory University, and the Georgia Innocence Project board member, Molly Palmer. Great to see everyone tonight. Renee Hill, closing arguments are so important, I think. Looking at the 2 styles that we saw there, what did you see? What did you like? What didn't you like?
Well, you are correct, Vinny, that closing arguments are the most important part of the trial because, like you said, that is the last opportunity that you have to speak to the jury. That is the last opportunity that you have to explain to them why your theory is the one that they should believe. And I think that during that time, you have to really connect with the jury. You want to connect with them all throughout, and hopefully by the time you get to your closing argument, they are connected to you and they are willing to hear what you're saying, not only just listen, but hear what you're saying. In this case, I did see part of the prosecution's closing, and quite frankly, I didn't care for it. I really didn't like it. I thought it was boring. I know that she did hit all of the points that she needed to hit, but I thought it was very boring. She didn't really engage with the jury. I think that the defense attorney did a very good job, the best that he could do with these facts. He was more engaging with the jury, and he pointed out all of the things that could lead to reasonable doubt. So it's really going to be who this jury is connecting with. And a lot of times, cases are won and lost in the summation.
And a big theme, Carmen, for the defense, no motive. We don't. And he says you've got to understand why to put all the pieces together here. But we know legally you don't.
Vinny, I got to tell you, I want to know why. I think the fact that this jury is still deliberating, and they apparently told the court, from what I understand, that they weren't close to reaching a verdict, means they may want to know why too. I mean, remember, the closing arguments are critical because, especially in a case like this, we've gone through so much evidence. But I thought the defense did a really great job of reminding us that there were other weapons, there were other suspects with a motive. There was even another vehicle that was similar to the one that was part of this crime. And so if I'm a juror, I'm going to have to go through everything to try and find out why. Because in this case, I feel like I need to know. So while everybody, maybe came into this thinking it's a slam dunk for the state, I think they're losing momentum on this closing argument. And because it's the last thing these jurors hear, I think it could make all the difference in this case.
All right, Molly Palmer, I know you're a true believer, but those orange fibers, which, by the way, match his daily attire these days when he's not in court, I think is huge. I think it's huge.
Yeah, I mean, but is it everything? I think a lot of people wear that color in that area of the United States, first of all. But listen, this case has to be proven beyond a reasonable doubt. So those fibers alone are not enough. And I would not be surprised. I agree with Renee and Carmen here. I think the defense has done an excellent job, and I wouldn't be surprised if we see possibly this ending up in a hung jury, because all you need is one person, just one, amongst those 12 to say, you know what, for me, it's not enough. For me, I am left with lingering doubt. And at that point, even if you only have one holdout, the case is hung, you get a mistrial, and then we have to do the whole thing all over again.
All right, here's a little secret. When my defense attorneys are saying all we need is one, that means prosecutors are ahead right now, ladies and gentlemen. All right.